Writ petition allowed, no order is to cost.
Obliged, my lord.
And at the time of dictating the judgment in WP 12717 of 2024, we find that WP
vacation, my lord. After vacation, on behalf of BP Mahanti.
Yes.
Item number 3.
Item 3 is a PIL. We are obtaining further instructions under the RTI, my lords. I pray come up after vacation, my lords. Government also, your lordships had asked the government to give instructions. I think they will have to give instructions or copies to us, my lords.
Here, actually, I would like to submit something, my lord.
Yeah.
With your lordship permission. I have been implicated as opposite party number 5. Your lordship remembers 2 bidders who contested and participated in the same bid, along with me, filed 3 writ applications. All the 3 applications.
There is no interim order.
No, but PIL, sir, kindly see what I want to submit you. Already same subject matter was already been dismissed by your lordship. And now, so they have set up these 3, 4, 5%.
He wanted an accommodation just before the
Yes.
vacation.
I bowed down. I bowed.
I was looking at whether interim order is there or
No,
not,
there is no
looking at what is.
There's no interim order.
Yes.
I bowed down them.
Item number 4.
So, if I may please your lordships, my lord.
30.
Gratefully, lordship.
Item number 5.
May I please? My lord, the present petitions files public interest litigation.
Yes. What steps have you taken to remove the encroachers?
I'll take instruction in this.
What is this?
My lord, as per page 22.
I understand.
Yes,
You
Lord.
have raised the issue that
Yes.
it is a government land, voucher land.
Yes,
They
sir.
are occupying it. The instant public interest litigation is filed for mandamus upon the government.
May it please your lordship.
Where is
This-
the tender?
The page 37, annexure 1.
Why you want a cancellation?
Sir, actually, a similar tender was floated. If your lordship looks at page 61, annexure 3, identical tender that was challenged before your lordship in a writ application, which is pending. And in that writ application, though no interim order was passed, the ground on which it was challenged, they have indirectly accepted it. Now that tender has been cancelled.
Yes.
After cancelling the same, they have floated this new tender.
So
If your lordship looks at, our submission is that this tender has been floated on the basis of a procedural order that was were prepared on the basis of an apex guideline, and the apex guideline has not been followed. As a result of which, when we objected to this, now they have recently sought for objection from the stakeholders. And when the objections have been filed by different stakeholders during pendency of that, because it cannot be finalized without hearing them. So it has been done again, floated before finalization of the same. That is, this indirectly it is also not correct.
No, if they have accepted the objection and they removed those.
Not accepted, Maharaj. Not accepted. We have
It's
raised
a replica of the same.
replicas. Exactly, Maharaj. Railways.
Union of
My
India.
lord,
What do you say?
my lord, in this case, my lord, I have been verbally instructed that this tender process has already been completed since 23/9/2025, and he has not participated at any time in the tender process.
Whatever.
So we will file counter to this
the
respect.
earlier tender, if the earlier tender containing all the requisites which are there was objected to by many intending participants, then without hearing the objection and without considering that what they have objected to, you have again floated a tender and hurriedly proceeded on that basis.
My lord, that is not the fact. In fact,
Qualification is attributable to them, then definitely they have a right to object.
my lord, that is not the factual aspect. In fact, what I have been instructed that he has
So,
never
if
participated
it is
in the
a
tender
replica
process at
of
all.
If it is a replica of
Replica.
the earlier one, where the objection was invited, several objections have been given. Have you taken care?
So that is why, my lord, I am praying just 7 days time may be granted so that I will file
You have-
counter.
At one go, you say that everything is over, and then you say the time is to be given so that I will consider.
My
So
lord,
then,
my lord, for the first time it has been listed. So let 7 days time may be granted so that I will.
inevitable. Suppose a matter is listed for the first time, that the adjournment is the rule.
No, not like.
So that is what it appears to be. I have been experiencing this from the day one.
My lord, then, my lord, your lordship may kindly, before rising, your lordship may. My lord, and DSJ will argue this matter, my lord. Before rising, my lord, this matter may be taken up. He will argue this.
What do you say?
My lord, before rising, your lordship, my lord, this matter may be taken so that Lord and DSJ will argue this.
No difficulty. Before rising, he what?
Yeah.
Item number 7.
180 ml.
What is this?
180 ml.
Oh,
Only one before puja.
yes.
Item number 8.
Was item 8. Item 8, Malots, I'm appearing to BC Malots. Malots, this is a matter where I've challenged the constitutional validity, which is a subject matter of challenge of Rule 16 of the Orissa Panchayat Samiti rules, Malots, that chairman matter. Your Lordships,
Yes.
your Lordships have kept similar matters on 16/10/25. Here, I have challenged the subsequent amendments which they have made following our writ application, Malots, because they realized there were mistakes.
Notice
So
to be listed on 1610.
16, yes, Malots. Let it be listed on with
Not
the
along with, but one after another.
yes, Malots. 16
Yes.
obliged.
Item 9.
Where is the very serious issue is raised, but who is the advocate on record? Where is he?
My lord, so see the instruction that I had given on the last day. It was Andhra Pradesh police who had detained the person, my lord. So my lords had raised the question whether any direction can be given to Andhra Pradesh.
There is no representation on behalf of the petitioner when the matter is called out today. Let the matter be listed.
Your Lordship, in this item, Your Lordship, the impugned is first appeal order. That in the impugned is first appeal order, which has been rejected on the ground of delay, Your Lordship. As like as yesterday's matter, Mr. My Lord and Senior Mr. Kara. So let it be tagged. So far as the payment is concerned, Your Lordship, he may not be directed to deposit 10%. Why, Your Lordship? His allegation is that he has deposited much more amount, Your Lordship. From so far as the deposit is concerned, we have verified he has deposited under the wrong head, in a wrong form, in a wrong head. So what I request my learned friend, let his client go to my office, because my office cannot do it, is only GSTN can open the portal. So let him go. I have instructed my officer to cooperate him and how to
Get the money
Your Lordship, because
transformed into this.
it is supposed to be deposited in Form 3A. It is supposed to be deposited because against liability register, it cannot be adjusted until unless rightly deposited.
Yes, ma'am.
Yes.
So let it be tagged with that 10% matter.
Mr.
Your Lordship.
This is assessment.
Your Lordship. First appeal against first appeal assessment. First appeal has been rejected on the ground of delay. So against that first appeal order, as like as 10 matter. So he for natural for liability register.
Yes, madam.
Yes.
August.
And so far as the appeal is concerned,
We will say that along with that matter, we will consider this.
Your Lordship. Good.
Yes.
Mr. Misra, yesterday's that matter,
Mal.
I have modified, I think, you see that Mr. Chorus matter,
Mal.
Finance Act 2025 has not
Yes.
yet been
Past 10, Your Lordship. Past 10,
so
I have
verified.
gone through that
It is-
notification
Has been
later on.
notified. Yes.
Later on, past 10, it will be.
So it will come into from 1st October.
Correct.
Till now, it is not.
Your Lordship, today also I want to mention that because yesterday evening I have verified that a specific
So first we
notification has
verify
come.
then submit. Otherwise, it is very difficult for us to.
Your Lordship, on the
Otherwise,
spot,
we would have signed it.
on the,
I checked up.
the spot. I'm sorry, Your Lordship.
Yes.
Item number 11.
Come and say that court has not come.
No,
11.
Item 11. My lord, this pertains to cancellation of registration certificate. And it is.
Your Lordship.
Wait for both the submit. Item 12.
May it please my lordship, I'm appearing on behalf of my senior, Mr. Abhijit Patnaik. My senior has been stock up in rain, my lordship. We are praying for a short passover, my lordship. Because of the rain, my senior is stock.
Yes. Now your senior has come. Sorry, Mom.
But here is a case. But here is a case where they are alleging that because of the bogus purchase, you are not given the ITC. My lord, first, in the GST proceeding, my lord, they initiated a proceeding where that
GST matter.
My lord, they initiated the GST proceeding, it was dropped after my reply. Thereafter, they started this faceless assessment. Where now, my lord? Page 15, my lord.
So there were transactions with there were allegations of transactions with non-existent dealers.
Yes, my lord. In the GST, my lord, we explained it, and thereafter it was dropped. They were satisfied with my reply. Now,
So
my
there
lord,
is no bogus
no,
transaction.
they never found out. GST department never found out. Again, my lord, in the 148, prior to my lord, in 148A proceeding, my lord, they were on harping on this GST, that GST department has found out everything. When, my lord, GST was found to be satisfactory and they dropped the proceeding. Again, in the faceless assessment, they started
Same allegation.
that's, but without initiating no more 148 proceeding, my lord, straight away they started the faceless assessment. Again, they should have, if they have, my lord,
Under 151A.
my lord, 144, faceless 144B, my lord, they started the proceeding. First, they started under 148A. Thereafter, my lord, 148 notice was given. Then 147, 142 notice was also given to me. My lord, after that, GST also proceeding was dropped meantime. Thereafter, my lord, after dropping of the GST proceeding, they gave me the faceless assessment notice, my lord. And it was culminated.
There you reply.
This is a matter of fake invoice, my lord, the bogus purchase, my lord, on the basis of the report.
That was a GST if the authority was competent in this regard, because on the basis of those fake purchase or the invoices which you are saying, if they have claimed any kind of a ITC or claimed any kind of a benefit, and if the authority found that it is not, can you sat over the decision of the competent authority? Is the GST authority who is competent to declare that particular purchase order or the purchase is bogus?
That is the only originating. It originated from GST investigation. So when those authorities were satisfied that there is no bogus purchase, then how, for the self-same cause, how can you, in a different capacity?
You are sitting as an appellate forum.
No matter the order has been passed on 4th March, my lord. So petitioner has not exhausted alternative remedy.
It's not supposed to be like this.
Well, alternative remedies are available to the petitioner.
So it is supposed to be argued like this. A question is put to you. Please answer.
Right.
How can you be an appellate authority, as my lord has said,
over the GST authority, who is the competent authority?
For the self-same.
If you take the instruction regarding position of GST.
Instruction. That's the law. So you are supposed to know the law. Authorities. What? You should answer. Can they? If the GST authorities did not find any, I would say, the remnants or any iota of piece of evidence that all these transactions are bogus, fake invoices, fake purchases, everything, can an income tax authority on the same point?
No.
Then that means they are really sitting as an appellate authority over the decision or the wisdom of the GST authority. Can they? We are putting a question.
Yes, sir.
Sure. No. Okay. On the same thing, you treat it as a bogus when the GST authorities did not find it a bogus.
Right.
It's got to be done.
Where is your GST order of dropping?
My lord.
Prior to a notice or after notice?
My lord, after notice, my lord. My lord, this is page 91.
Now, after notice of 148A?
Yes, my lord. This is, my lord, after, my lord, 148A. 148.
148.
Yes, ma'am. My lord, it is 26/11/2024. This is reference to your reply dated 20. My lord.
Relevant dates of the notice, the order of GST and everything.
Yes. First, my lord, may take the.
You have prepared the date, sir.
My lord, it is in the petition. My lord, may take the date of 148. My lord, is the date is, my lord, 4th. This is, my lord, 11/3/2024 is 148A notice, my lord. 11/3/2024. Thereafter, I have given my reply, my lord. Then 148 notice is 21/3/2024.
Yes, and then
GST was, my lord, on 3/9/2024.
so much after.
Yes, my lord. Then, my lord,
Where is that?
my
You
lord.
have not disclosed
Yes,
that.
yes, my lord. That
In the
is
date chart.
not in date chart. Sorry.
That's why we wanted all those
My lord,
dates.
sorry, my lord, sorry, my lord.
So that it will be easy.
My lord, my lord. I'll give in a detailed date chart to that, my lord. My lord, Annexure 8 is the GST notice, my lord. Thereafter, my lord, on my lord, on 26/11.
Why don't you? Oh, that assessment is already over.
Yes, my lord.
You are not enclosed it since GST order.
The GST order is there, my lord, at page 91, my lord. Date of acceptance of reply against the notice dated under section 61. So they found that your reply has been found to be satisfactory. No further action is required to be taken in this matter. And after that, my lord.
That is 26/11/2024.
Yes, ma'am. Then on 13/2/2025, they initiated 144 matter. The so-cause notice was given.
Did you give the reply?
No, my lord.
Disclosing this fact?
Previously, I had given the reply in the
In
notice.
this notice, have you given a reply?
No, my lord. We have.
Why? You should have cited.
My lord, we have not given because
and straight away you come to the court.
Thereafter, my lord, the computation has been given, my lord. Without now they're demanding penalty has been initiated. Penalty proceeding has been initiated.
Then who is responsible for this?
My lord, reply has to be given.
Then
sorry, my lord, regarding that reply has not been given. If my lord will just give us the concession, then my lord will go and file our detailed reply over the authorities. My lord will explain the entire thing to them.
Nowadays we are live streaming. Otherwise, I would have reacted to that word sorry.
Sorry.
In annexure also, they have only attached the computation sheet, no order. In annexure, my lord, so only they have annexed computation sheet, no order. In annexure.
But after all, when it is a fact, may not be. We can't say that it is not. But these are the disclosure. When it has come, then you should definitely take into consideration, because on the face of it, this order, had it been disclosed to you, I think the authority, you would not have proceeded.
Even by me, my lord.
No, sir, then you'll have to give. We
Yes,
have to see.
I will
If
give.
the reason being
Right.
the what you say,
Yes, my
then definitely you have a good case.
my lord.
If the reason is something
Reason, my
different than
lord.
what you say,
My
then
lord,
in that event, sorry.
My lord, the reason, my lord, kindly find at this is 148 notice in the notice, my lord.
148.
My lord, I got it. My lord, that reason.
There.
Yes, my lord.
148 AO is over.
Yes.
Now 148 notice thereafter comes.
My lord.
144B.
Yes.
144B.
144B, my lord, notice. They have given me the notice 144. My lord, I am giving that.
No, you enclose that.
My lord, that
enclose that letters.
Yes, my lord. It is the notice has been given, my lord.
No, sir, you give that reason portion of that assessment order into
So,
my lord. The
so at
faceless
least
assessment order.
Give the notice. Notice also.
Notice is there, my lord. 144 notice is there at page 98.
We are not now on notice, sir. We have to show
My lord.
indulgence in the assessment order.
My lord.
Where
my
is that order?
My lord, that order I will.
Order you have not
Yes,
disclosed.
that I
That
will.
is the issued order.
Yes, ma'am. I'll enclose. At page 98.
That
90?
is book
8,
which I have
144 notice, my lord.
Where do I get it?
My lord. At page 98, my lord.
I am
And-
looking at it. Where it is indicated?
My lord. My lord, at page 100, my lord, 2.4.3, the assessive at paragraph had furnished a reply on 26/6/2024 and stated that he had made purchase from Sony Iron and Steel Trading.
No, that is I'm talking whether it is a notice.
My lord.
Where do I get it?
My lord, here.
Oh, at the bottom.
At the bottom.
At the bottom.
Yes.
Page 102.
Yes, 100.
Page 102, just above the column.
Yes, ma'am.
Just above the column. Yes, yes, yes. Yes, bring that.
Right. I'll bring that. After vacation, my lord.
Item 13.
Item 13 made, please, my lords. Item 13 pertains to 151A baseless assessment. In my case, the 148 notice has been issued by the jurisdictional assessing officer. In similarly situated matters, the lordships are fixing it to 10th of October. The only slight modification needed, my lords, is that I've challenged the assessment order, but it goes to the root of the matter, my lords.
Yes.
Please, Your Lordship. Your Lordship, item 14, due to non-possession of GST Tribunal, First Appellate Authority order challenging.
10%.
Item 15.
Multiple years, my lord, show cause notices have been issued. Multiple years of show cause notices have been issued.
I have one question. Here, my lord, one recent development is there. The Delhi High Court has already said that the multiple show cause notice is permissible, and it has filed
With great respect, my lord, that was relating to
ITC, fraudulent
nothing to do
ITC.
with this. It is Honorable Justice Pratibha Singh's judgment of Delhi High Court, my lord, was relating to an ITC fraud, where they said that this multiple clubbing of multiple years will not be a bar. They have not decided on the issue whether the periods are different. They have not decided the issue of 74 subsection 10, my lords, and they have not decided the issue.
You are perhaps now reminding me of that judgment. I'm not able to remember.
We are
that
not
number.
bound by the judgment.
My lord,
We are in a division bench.
my lord, I am conscious, but one thing, my lord, this case was gone up to the Apex Court.
Apex Court for the ratio decided, not something else.
But after arguing with the 1 minute.
Our High
It
Court.
was implicit dismissal at the special leave petition.
Yes, my lord.
Please read the judgment.
My lord, I have given the
Apex Court.
My lord,
I think 2000.
yes, my lord, I am
judgment
ratio.
Judgment. It does not tantamount to a merger.
My
Please
lord,
go and read.
here, my
So
lord,
we are still not bound by the.
my lord, I am conscious.
We are insistent of the matter. Let us decide.
In our court, I am reminded of one judgment of division bench saying that 1 year separation cannot be included for the purpose of best judgment assessment in another
Here, my lord,
another year. So if we come to hold that each year is separate component of
This
assessment,
is what we are stuck up with, because this
Yeah,
what
good,
you
good,
is
yeah.
very consistent.
Every day when they are
My lord.
individual.
So in that event, that we have to follow that
My lord.
our own High Court judgment to be followed, or so we'll consider.
My lord, I'm not standing on the way, but only thing it was dismissed as
No, with
withdrawn
the- with
after
the-
hearing for
with
some
the-
time.
your file response
My lord, I
will consider.
with the sense of pride and the smile that's I noticed in your face.
Thank you
welcome. Bro.
for your objections.
We have noticed our High Court judgment. That's why we kept all those matters. Let us see whether
Only
it
thing
can be
tempted
referred
me
a
to file
larger
this
bench,
because, my lord,
or we agree to the decision.
only thing tempted.
Decidency has to be followed.
Yes,
With
that,
great respect.
yeah, that is there. That is there.
Everything cannot be loved.
That I
That's
cannot
what I say.
And my learned friend, yes,
He's doing it
he's
well.
doing well, and he's
He's doing his job.
No. When there is a conflict,
Absolutely. That itself is
the same equal strength bench judgment of another High Court and of the same High Court.
My lord,
The
the bound
question is that which has a binding precedence.
my lords are bound by my lord's judgment.
On the coordinate case.
Absolutely.
That is what we have to
That is the
consider.
only point.
If we think that we want to take
Yes.
a dissenting view, then we can
And
take a
refer to
dissenting
the
view and refer the matter to a
larger bench.
It's not difficult.
You see, great number of advocates are against.
So that is the point we have kept it.
my learned
Let us
friend, Mr.
decide.
My
We'll
learned
consider
friend,
this judgment as well.
my learned friend, Mr. Christie, has dropped a bombshell. Them also were taken by surprise.
That we face many a times.
They did not expect Diwali during Durga Puja, Milods.
Good for Mr. Kaur, my lord.
No, both of us faced many a times.
And my lord, one thing I should say,
He says,
for taxes,
don't hurl bombs during pujas. You can
Flowers, my lord, yes.
I
Green
think,
pepper.
the
Item 16. Item 16. Yesterday's matter. My apologies, my lord. Yesterday, I could not point out to my lord that who is appearing for the corporation. Because, Mr. Somik Tripathi, he is appearing for the corporation. He has been authorized and he has also filed Wakalatnama beforehand. My lord.
May I please, Your Lordship?
Today he is filing the counter affidavit.
At the very outset, my lords, I will accept my apology, my lords, for the inconvenience caused to the Honorable Court yesterday, Lordships. This came the specialist, my lord. I missed my mind matter, my lord. It's all my fault, my lords. It's my sincere apology, my lord. Lordships, as per the last undertaking, my lords, we have filed the counter affidavit, my lords. Nothing, most of the documents are already read petitions, just to show that most of the documents are already in the read petitions, my lord. We have filed this counter affidavit, my lord. Lordship may kindly accept it. Lordships, we are just showing some more documents, my lord, which will demonstrate that there is no mala fide as was contended by the petitioner, and the thorough process of evaluation was conducted. And after that, the price bid was open.
No, they are raising a point, if I correctly understood, yesterday on a very, I think, the finer or the thinner proposition. They say that there is no dispute from the tender document that the participants have to show that they have their US FDA or
Certificate.
that certification
US
is
great
required.
one.
So they say that the certificate number which they disclosed, the successful bidder, after the verification was found to have been given to a company which is
Shanghai.
which is registered or operating in Shanghai,
Right.
not in India. So it does not belong to the manufacturer of India,
Right.
who has given a certificate. So if the manufacturer has not
Registered.
got that particular certificate, and he gave a declaration 87 which is the requirement, that I have been given this certificate. He cannot use the certificate issued to some other company outside the country.
Certainly, my lord.
So say that the entire thing is not in compliance with the requirement of the tender,
My lord.
and therefore you ought to have disqualified him.
My lord.
Right, right, sir.
Lordships, I would.
So that
assist
was the
my
question your lordship asked me yesterday. Can I explain it, man?
Lordships,
Because I am the person who actually got the tender.
You could not explain because your juniors were not assisting you.
Well,
properly
now I can
yesterday.
explain today. Man.
Lordship, before
I
going to
can
the merit,
explain
my
today.
lords, before going into the merit of the case, my lords, I would like to
This is
assist.
not merit. This is
I'm-
the only point.
coming, my
That's the only point. That's right.
There is a preliminary objection, my lords. This writ petitions could not have been it's not maintainable, my lords, because the writ petition has been filed by somebody who has not been authorized by the board of directors, my lords.
Oh,
That's a
who
preliminary
are you?
objection only, man.
Are you a shareholder of the company? Are you a director of the company? Are you anyhow associated with the company?
My lord.
It is their internal management, the affairs. And there are getting of judgment which
Yes, ma'am.
says that these are all, they will come with a resolution, board
Yes,
resolution.
ma'am. That's what the Honorable High Court, our High
Sir,
Court and on the
the
Apex
Supreme
Court
Court also it
yes, ma'am.
says it's not a fatal one.
Yes, ma'am. Certainly. Yes, my lord.
It
Yes, ma'am.
shows that they've got nothing to say on merit.
Yes, my lord.
Order.
And
Without disturbing High Court's order.
Yes, ma'am.
87 Supreme
Liberty has been given, my lord.
32.
Yeah, 1987
Yes,
Supreme
ma'am.
Court or 97 Supreme Court.
87.
It's not fatal.
My lord, I'll just explain your lordship's query, my lord. Well, if your lordship permit me, my lord, I'll take 2 minutes for to explain.
No, he's come with the
Right.
with the enormous reposition of the energy.
Eventually, I'll be
Let him-
affected,
let
my
him
lord. That's
exhaust
funny.
first.
Yes, ma'am. Lordships, the tender terms and conditions, my lord. That's a clause V of clause 7 of the NIT, my lords. That's page 117 of the paper book. Lordship,
Please read that.
yes, ma'am. I will just trouble my lordship with the 4 lines.
Yesterday you were not there. There was a threadbare argument on that. Please
I'm
read
coming, ma'am.
107, 17, 107, 156 or a 55. Read those.
I'm just assisting my honorable court. Just give me 5 minutes, my lord.
Mr.
The first
Chatterjee, probably, I think the corridor is the best place for argument.
point number 1, my lord.
Unfortunately, in Calcutta High Court, Milord, is going on full-fledged today, Milord. There is no empty courtroom at all. I'm sorry, Milord, but I really couldn't find a place. I'm really sorry.
Yes, my lord. Page 117, my lords. The first condition, the quoted model. Lordship, may I lay emphasis? The quoted model should be US FDA and UC certified, my lords. What the petitioner is trying to confuse the honorable court with a submission that the manufacturer is supposed to have the US FDA certification, my lords. What clause point 1 says, my lords, is the quoted model that should be US FDA and UC certified, my lords.
That
And to
means
show that,
what does it mean? The certification is optional.
no, man, not at
So
all. I'm
it
coming to
should
the
be- and the successful bidder is also saying that yes, but I have quoted it.
certainly, my lords. I'm coming that, my lords. First, the model. The model is an ultrasound machine, my lords. That's a 70 affinity ultrasound machine by Philips. Lords, you may come to page 732. That's a US FDA. I will just assist the honorable court directly with respect to the pages, my lord. Page 732, that is a US FDA certification, my lord.
By whom? By whom?
By US
The
FDA.
T7 form. By whom? 732.
732 by the US FDA, my lord.
US FDA is that they have given this number.
My lords, US
What is-
FDA?
Yes.
Yes, my lord. So,
What is this? 732.
this is the US FDA certification with respect to the
Better.
particular model, which is Affinity 70
Oh.
diagnostic ultrasound machine, my lord. This is the US FDA certification for the particular model. That's the ultrasound machine we are supplying, my lord.
No, actually, he was not there yesterday. Your lordship got the question.
This what he let me understand that where he's heading.
Right.
Then I will put a pertinent question to him.
And next comes to the UC certificate, my lords. That's a page 805.
Tell me, is the certificate a mandatory requirement?
Yes, my lord.
Right. Any distributor or the manufacturer who intend to participate must show that he has this certificate.
Yes, my lord.
What certificate number they disclosed in their bid document?
I'm reading from the bid document only, my lord.
I'm asking, I understand. It was all argued. What number was disclosed in the bid document? K182, if I correctly remember by this.
Sir, that is the device number.
857 or what?
So that is the device number. Sir. K182857.
So my memory has
right. Your lordship, right to remember.
Still there it seems.
Now, once that means that this is what a USFT is certification
Yes,
number.
my lord.
He has disclosed the document in the writ petition at page 400 or something. What is this?
So 833 and 730. 833.
Please read that document. That's a long downloaded server copy.
833.
Please read.
Yes, ma'am.
Correct. Do you find that particular number there? A182857.
What I'm submitting,
Do you please?
No, my lord.
Did you find that number?
No, my lord.
It is there.
Did you find the number?
No, it's submission number K1185857, my lord. 18285.
Same number.
My lord.
Just a little above. Establishment name. What is
Philips
this?
Ultrasound Shanghai.
So it is given to Philips Ultrasound Shanghai Limited, who is registered office at Shanghai, who is registered company at Shanghai, and not in India. Right?
Yes, ma'am.
So it does not belong to a company, maybe a Philips, main subsidiary or a parent, incorporated in India.
My lord.
If it is not if it is incorporated in India, he must have a separate number. That is what they say.
What is that is their argument.
That's their wrong submission, my lord.
That is
Mr. Mishro, I am conscious. Sir. That's why I say that is what they say.
Yes,
I have conscious because I find it's a point of debate.
Sir.
So that's why I anticipate. What is what they say? That this does not belong to Philips India Limited,
my lord,
but a Shanghai Limited,
my lord.
Right? So they have misquoted that particular certificate number. If it does not belong to the manufacturer, then the distributor, he cannot use that because T7 form, which is next to the tender document, requires a certificate by a manufacturer.
Now coming to it.
Correct. So he raises a doubt or suspicion, rather I'd say, it's not doubt, a suspicion that he is not entitled, having not complied that mandatory term.
Now, my lord, what's a US FDA certification, my lords? US FDA certification is the quality certification, my lord, which is given to a product. It's a product specific certification. So any certificate given by the US FDA is pertaining to the particular machine, that is the 70 Affinity Philips in the instant case, my lord. So it's a global certification.
That means I accept. That means the ones they have given a certificate to a particular product, then it is irrelevant that this product is manufactured in any corner of the globe. It will automatically have an implied certification of US FDA.
No.
Is it
what I'm saying, US FDA certification.
I have a greatest of doubts.
US FDA certification is there are given qualities that has to be followed for particular product, my lords. That's why it's like India ISI certifications that US FDA.
Again, I'm saying that whoever is manufacturing, he has to obtain a certificate.
What I'm differentiating, my lords, what I'm trying to assist the Honorable Court. Lordships, we are at a case, my lords, the clause 7, my lord, that differentiate between two things, my lord. First, certification with respect to product. Second comes, my lord, certification with respect to the manufacturer. All those conditions have been mentioned in the clause 7, my lord. Maybe
I do not find it.
I'm coming, my lord. Lordships may kindly come to that annexure again, my lords. I will just trouble my lord.
You are interpreting in a, I would say.
I'm just trying to assist my lord. Yes, ma'am.
Yes, wait, page
117, my lord.
Yes.
The tender terms and condition, ma'am.
Yes. Yes.
First one, the quoted model. This condition is with respect to the particular product and model, my lord. The quoted model should be US FDA and UC certified. The UC certificate should be issued from so and so. Next, my lord, this is the condition with respect to the manufacturer. Condition number 2, my lords. Condition number 2 and condition number 4. Condition number 2, the line begins with the manufacturer of the quoted product should have an EN ISO 13485 certificate issued from the notified body or ICMED 13485 with or without plus certificate issued by certifications bodies accredited by NACB or ISO 13485 certificate issued from a certificate body accredited by NSBSB or Nationally Recognized Accreditation Board under IAF MLA, my lords. This is the certification with respect to the manufacturer, my lords. First one is with respect to the product, particular product we are supplying. Second is with respect to the manufacturer, my lord. And condition number 4, my lord.
Not even a product, it is a model.
Model.
It may be ultrasonography
Yes,
machine may be of a different.
Correct, model.
Is a model, particular
that's
model.
why intentionally it has been used quoted model, my lord, in the first condition. And the condition number 4, my lord, again a certification which has to be acquired by the manufacturer. 3 also, my lord. The quoted model should comply with IEC 60601 oblique 2-37 or equivalent. This is the basic electrical standard, my lord, which the machine should comply with. This is not a certification but a standard which the machine needs to be complied with, my lord. With respect to this condition, my lord, if the successful bidder fulfills all those 4 conditions, my lord, 4, my lord, the quoted model of the medical device must be registered under CDSO, that's the Government of India Enterprises, my lord, and submit the license to the manufacturer for sale or for distribution of the medical device.
Not manufacturer. And submit the license to
Manufacturer, license to manufacture.
Manufacturer.
My apology, my lords. I misread it.
For sale or for distribution
of the medical device, my lords. Yes, my lords. So I'm coming to the CDSO certification now, my lords. Page 820. India, my lords, which also a part of the Philips USA. Lordships, that this is license number, my lord. This is CDSO. My lord.
You're referring 820?
Yes, my lord, 820. CDSO certification, my lord. This CDSO certification is with respect to the manufacturer to manufacture or market, my lords. The first, it starts with Majors Philips India Limited, who is the manufacturer in the instant case, my lord. Manufacturer of the product, Philips India Limited, has been licensed to manufacture for sale or distribution of the below listed medical devices at the premises situated at Philips India Limited, plot number so and so, and telephone so and so, my lords. And the machine which I'm manufacturing, my lords, at serial number 1. That's Affinity 17 Diagnostic Ultrasound System, my lords. So the successful biller has qualified with respect to CDSO registration, my lords. That's not in dispute.
The thing is, when we talk about the model, it is not a talking about the device. And when 117 put the 4 conditions to follow, and it does not say that either of the conditions have to be followed. If all 4 are mandatory, if one is lacking, then will you That's the question.
Yep, I'm certifying. I'm just satisfying my lord.
That's the first. He
Yes.
is banking upon the first clause
Yes.
that the quoted model should be the USFDA
Grateful.
and EUCE certified.
Grateful, my lord.
That means it should have been certified
By US FDA.
Now to who?
To whom? The model, my lord. The quoted model, not the manufacturer, my lords. What they have been trying to do in the whole writ petition, my lords, they are.
So that is what I asked. That if it is only relatable to a model,
Yes, my lord.
then any manufacturer, even across the globe,
No.
who is manufacturing, is not required to approach, because this is already certified by US FDA. I am manufacturing this specification. I do not. So,
No.
so certified means there must be a general certification or a specific certification.
Yes.
What is that?
So specific certificate.
Specific. Then it must be issued to every manufacturer who is manufacturing
Of
that
particular model.
and does not relate to a model and then use omnibusly.
Grateful, my lord.
Only the product.
You are saying this. You are grateful, but you are arguing differently.
Just I'm trying to clarify, my lords. What my lords, what's
We are
coming
not
from my lord is that
concerned with ISO certification. We are not concerned with any CDSCO because he has not raised any concern.
the only certification
have.
my lords is concerned
Only
is
thing is whether
US FDA and
certification.
UCE.
What the certificates are.
US FDA and UCE certification. That's the both certificate.
That's why he has quoted the certificate number.
Yes, my lord.
And the certificate number appears from his document, which
Madam,
he is relying on, belongs to other company, not Philips India Limited.
My lord.
But
My lord, coming.
Philips Ultrasound Shanghai Company Limited. This is what he says.
Lordships, what he is relying, my lords? Annexure 7. Lordship, might kindly see what's 833. The nature of the document, my lords. 833. The Philips USA, my lords. It has different sub manufacturer, my lords. The details can be found in the UCE certificate, my lords. Lordship might kindly come to the next that explains in details with respect to different entities how the certificate is given, my lord. Page 805. At the point number 1, my lords, there are two compulsory requirements, my lord. First is US FDA certification, my lord. Second is EUC certification. Both are compulsory for the particular model, my lords. Now coming, my lord, this is EC certificate. It's Philips Ultrasound Inc., the same company in USA, my lords. Then, my lords, kindly come to page number 808. That's a continuation of the certification, my lord. How these certificates are given, my lords. For the particular product, my lords, and the subcontractors. It includes Philips India Limited. Second is Philips Medical System Netherlands.
That is what is I am saying. Sir, 117 does not say either or.
Yes, my lord.
It says and.
Yes, my lord.
So it is both the US FDA and EU certificates are mandatory.
Yes, my lord.
So if the EU certificates have indicated every, I would say the subsidiary or any company,
yes, my lord,
which is incorporated in any country as a separate entity, which under the corporate law is well known.
Yes, my lord.
Then in that event, that's why they have used this particular Philips India Limited as a part of that. Whether this Philips India Limited has been used in US FDA certification.
Yes, my lord. Okay, what my humble submission is that, my lords, there are difference between the working style and certification of different agencies, my lords. What US FDA certification says, that's my instruction, my lords. What US FDA certification says, my lord,
Sir,
it is only
you are a tendering authority.
Yes, my lord.
When you know that these are the problems which come, then you should have made a very, very, very specific averments in that particular tender document. There was no fetter on your part to incorporate any conditions in the tender document.
Lordship,
as a tender inviting authority, you can.
Lordship, on the same, Lordship, all due respect, my lord, on the 2023 tender, my lords, they came out successful. The same HOSCO, my lords, with the same certification, they never disputed. Now, as they came in the came L2 in this particular tender, my lord. Now they are disputing the US FDA certification.
They say that my certification cannot be questioned.
Yes, my lord. What I'm saying, my lords, the
If
US
their certification cannot be questioned, and if they have raised a doubt on the certification of the L1, then will you say that you will not take into account? This is what they want to say. If that corroborates their stand that even an EU certificate which is there incorporates Philips India Limited
Lordship,
as a separate
the EU certificate gives it to the Pune company, Pune manufacturer.
Lordships, the US FDA certifications, my lords, as per what my instruction says, they never describe all those subsidiary sub-manufacturers under it's given to a particular model globally only, my lord.
The company is Philips Ultrasound.
Yes, my lord. Yes, my lord.
Netherlands.
And
so
they are incorporated in another part of the, I think, the globe.
Yes, my lord.
Netherlands
country. But since they have their existence globally in every country, so they have incorporated as their subsidiary companies in every country and under the particular country's corporate law.
Grateful.
So they have been incorporated in India. They have to comply all the laws applicable to the company in India. They cannot take advantage of the corporate law of the another country. So if they have a separate entity as a subsidiary, then in that event, what is your perception?
Lordships,
what is the corporate law says about it? Let me understand. You are going to such an extent. Let us understand that what is the implication or nuances of a company being incorporated under the Companies Act of the country, though the parent holding company is registered in another part of the world.
If I'm correct, my lord, I'm just trying to understand, my lord, what's coming from my lord is that whether this US FDA certification that's at page 72, which mentions 732, which mentions with respect to Philips Ultrasound Inc. It has been issued to Philips Ultrasound Inc. That's not even.
Right.
No, my lord, 732.
That is another certificate.
No, my lord, this is the US FDA certificate.
Oh, this is what they say, but it was registered to a Sanghar. That is what they say.
Yes, my lords. Now I'm coming, my lords. First, my lords, let's coming to the certificate. What the certificate particular number is, the standard is. It's not just US FDA. It's US FDA 510K. That is a particular standard for which US FDA issues the certificate, my lords. 732 is a particular certificate, US FDA 510K, my lords. The first para. We have reviewed your section 510K, that is the regulatory provision of US FDA, my lords, which needs to be complied with if somebody wants to get a certificate for the particular model from US FDA, my lords. We have reviewed your section 510K, pre-market notifications of intent to market the device referred above, and have determined the device is substantially equivalent for the indications for use stated in the enclosure to legally marketed predicate devices marketed in the interstate commerce prior to so and so, and the enactment date of the medical device amendments or the devices so and so do not require approval of a pre-market approval application PMA. You may, I lay emphasis, my lord, you may therefore market the device subject to the general condition provisions of the Act. Although this letter refers to your product as a device, that is the Affinity 17 diagnostic ultrasound machine, my lords, as a device, please be aware that some cleared products may instead be combination of products, my lords. So this particular certificate was given to the Philips Ultrasound Inc., my lords, for manufacture of a particular product, that's a 70 affinity, my lords, and to market it globally, my lords. It's a global certification for a particular model, not for a particular manufacturer only, my lords. And lordship, what Unlike the USI certificate, my lord, which explains all those sub-manufacturers also, my lords, what my instruction says, US FDA certification only says about the model. The REK 182857, that's a number, my lords, that is given, this certificate number is given to the particular product, that is Affinity 70 diagnostic ultrasound machine. Not, this number is not given to Philips Ultrasound Inc.
He quoted the same product with the another US FDA number given to him by the same US Food and Drug.
Lords,
We
petitioner.
find a difference.
Petitioner. No, sir.
No, not yes, petitioner.
No, petitioner has not given.
Yes, he has given.
Sir, petitioner certification is a different model.
No, the same model.
No, sir, different models.
No, the same model. I was going
petitioner. So petitioner model, if you also kindly see, my lord. I'll just show that. The page 190. Page 190, let's say kindly see. That is T2 certificate, my lord. 190. The model is different.
No, same model.
So,
specification.
But it's the same machine, but the model number would be different.
Yes. Model number is different.
Yes. There is a lot of respect to my learned senior friends there.
Just a minute.
Entire process is probably not very clear to them.
No. Just a minute. It's clear, sir. I'll explain that. Sir, page 190.
Especially the tendering authority.
The model is there. Lordship looks at.
Ultrasound must be with 4 probes. So 190.
That is, name of the model is MYLAV X8 EXP.
Correct.
Model number.
Is a model number is a difference.
Right.
The model is something because the model is 510K, which they have said.
So the ultrasound patient 4 probe is correct. But model number is different and the
510K is the regulatory provision, my lords, for which the US FDA certificate is given. That's clear from 732 page, my lord. There's a particular provision, 510K.
But kindly, my lord, if I may, my lord, interject here, kindly let my learned friend show your lord.
It is also under 510K.
Yes, my lord, 510K. But the model number is different.
Model number? It's the same device. And there will be a one, according to him, it is given to a model. I believe that, I do not think that it has been correctly done. What he says is.
Can I explain, my lord? My friend has argued. I'll just explain, clarify your lordship.
Because the way he's arguing, I think that is strengthened more the case of the petitioner.
Well, I'll just explain within 2 minutes, my lord. Just give me 2 minutes, my lord. Give me 2 minutes. If I don't explain, then you know. Well, kindly look at page 732. This is our certification of US food drugs, my lord.
Correct.
This certificate is a product certificate, my lord. The model certificate.
Correct.
Model number is K182857, my lord. The number is given.
Yes.
If your lordship looks at page 805.
This is the model number or is a US FDA?
No, sir, it's a model number. It's a model. Same model number is used by Shanghai also. If your lordship looks at.
Correct. Let's see.
That is exactly I wanted to show.
Correct.
Page
833.
833, my lord.
833.
Right.
Yes. Yes.
But 833, sorry.
Yes, I got.
Yes, 833, establishment, registration and device listing.
Correct.
Well, I got it. Yeah. But this establishment, registration and device listing means they have to register under FDA for the purpose of exporting this product. Product is K8182857. This is the model number.
Right.
To US for commercial marketing. But we have also this Indian manufacturer is also got the same certificate. Lordship looks at. But we did not file because it was not required on the tender document. Right.
This is a new document and I don't know what it is.
Because it's not required.
Because he says that he has not been given an opportunity to file the counter.
Counter, right?
So he's placing those.
Very well.
He is also downloading from the
Yes.
same.
Yes, madam. So kindly look at this document.
But if my my learned friend is there, my lord, my counterpart there, if he has a copy, my lord, he can take a screenshot and send it to me so that I can.
Who is the counterpart?
Mr. Tanmay is there, my lord.
Given, already given.
And then give.
It's already given, sir. Already. This is for establishment, registration, and device listing. If your lordship looks at the device number is same document. This is K182857.
I received, but Philips India Limited.
Philips India Limited.
I got it.
Well, this.
So that is what I say.
No,
here, same US Food and Drug.
That is Shanghai.
That is. What is notice is that both the documents, I do not know, from this 833, it appears that they must have downloaded it from the official website of the US Food and Drug.
Right.
You have also downloaded this document from the US Food and Drug.
Because we have registered.
But it appears that, yes, there they have shown as the Shanghai. Now it is shown as the Philips India Limited.
India. Right, India. So this is for exporting the product.
The distinction.
What is the distinction?
Same document, Bharat.
US Food and Drug Administration.
Yes. Correct.
This document you see, that is FDA.
FDA, US Food and Drugs. That's the complete certificate.
US is not there. In 833,
Yes.
US word is not there. Here it is there. Here full form is.
No, what my brother is saying that there is some kind of a difference between this document and 833.
Sir.
If it is downloaded from the official website,
right,
then they claim that they have also downloaded it from the official website.
So this is our certification.
Well, there is one more thing I may point out. Kindly see the last the specification developer, not a manufacturer.
Yes.
Specification developer.
Not pre-validate this. So this is what the certificate number is given.
Here Shanghai word is not there, and you see registered establishment number that varies.
Right, sir.
From your document which you have supplied to us.
Yes.
Registered establishment number column you see that
different.
Page 833 it starts with 30054.
Sir.
But here it is 3033.
The registration number is 892-892-1560 is 1550.
Different establishments.
So the different establishment. This is India. That is Shanghai.
But I am saying there is a variance, and this logo is also
yes.
This
is a screenshot we have taken.
But I find the owner or operator number is same.
Yes.
Operator number is same.
Same product, Millard. Same product name cannot be different.
Later when I say.
Sir.
It is used at page 833 is a manufacturer.
Yes.
And in this document it says a specification developed.
Sir, US, this is a certificate issued.
That actually means, sir.
No,
This establishment registration device is there, my lord. Kindly see, I have given that document.
Sir, 834 makes it clear.
Sir, I have given that.
834, page 834, that makes it clear that this document may not be from the website of web portal of US
What
Food
is
and
this?
Drugs.
What is this?
So this document shows that this registration is required for this purpose. For front page it is mentioned, madam. Establishment that involves in production and distribution of medical device.
No, establishments that are involved in the production and distribution of the medical devices
in the
intended
United
for
States.
commercial distribution in the United States.
Yes.
Including those that are imported for export only.
Export only.
Are required to register annually with the FDA.
Yes.
Establishments that are required to register are also required to list the devices.
Correct.
And the activities performed on those devices at that establishment.
That is 833.
So Shanghai supplies to America.
So Shanghai supplies to America.
Do one thing. Bring those the facts by way of an affidavit.
Sir, I am filing the counter also.
We are inviting to file a counter.
Sir,
address.
Milord, in the meantime, Milord, let them not, Milord, finish off the work orders.
Not yet.
will it be my lord's pleasure to fix it on a
Or
date?
17.
Will it add
Yes,
to
item number 17.
my lord? May I pray for one more thing? Will it be my lord's pleasure to my lord
Same
fix it
matter,
on a
my lord.
date at 2 p.m. my lord?
Lord, I'm handing over the affidavit.
There is a delay.
My lord,
There is a delay.
4 days.
Oh,
4 days. That was,
Delay. In fact, it said that to condone 4 days.
my lord, actually 3 of them, they could come, my lord. And others, for others, appellant number 1 has undertaken. My lord, because of incessant rain and 75 years old person, my lord, they could not come, my lord.
if they violates, then what will happen? So I can just record your submissions and an undertaking from your end because you have secured only the undertaking.
Yes, my lord. Yes, my lord. Yes, my lord.
And keep this on record.
Yes, my lord. Yes.
Delay has been condoned or not?
Delay condoned, my lord. Condoned.
Only
On the
Has
first
been
day,
condoned.
yes, my lord.
4 days delay. So I said
Oh,
earlier.
whatever, there must be. After all, it requires a no. There is no order pass.
And last occasion, Lordship, I said.
Oh, I will. That is what I will. Then I have to. No, file up. This is the application for condonation of delay
Last Lordship may permit me to withdraw that petition.
9.
Item
What happened? 9
WPCRL number 131 of 2000.
Somebody says before rising
Yes, that's
one matter.
Item 6.
6. 9 he wanted to withdraw. Give. What is this 6?
that matter
Grateful
that tender matter merit.
Urgent or it will come after vacation?
Sir, here actually what happened, the same tender has been floated after the invite.
Oh, that is what you
Yes, yes.
Yes, Mr. DSG.
Yes, my lord. In this
Yes,
case,
yes.
earlier they filed a writ petition.
Yes,
No
challenging.
was passed.
Correct.
Thereafter, the department desired to go a fresh tendering for floating the tender because there is some discrepancy. After that, they are coming and file for first time. It was listed. Let's me keep it after vacation. I will take with instruction, my lord.
Don't proceed with the tender.
Right.
My lord, last occasion the same player they have come, and after considering the same, my lord is not passed any order. So, Lordship may issue notice,
That
but
is
as regards
cancelled,
to
yes,
order is
that-
concerned, I am
Well,
urging because the first time it was
what
listed.
he says is that he raised an objections and the objections were under
And
consideration.
they didn't have any locus to object because they have participated in the tender.
This tender is
Did
the
not
replica
participate.
of the earlier one, according to him.
Yes, replica of the same. So kindly see 163. Page 163.
My lord, last order I am reading, my lord.
Page 163.
Just a minute, sir. I just did. This last order is 6/5/2025 in 1100 of 2025. In that order, my lord, I am reading preliminary counter affidavit filed by the OP number 1 to 3 is taken to record. Copy of the same is served on Mr. Mahantil and counsel for the petitioner. Put of this matter on 12th May 2025, on which date the Mr. Land senior counsel senior advocate shall explain as to whether the petitioners are stakeholders or not, and also apprise the court as how the petitioner are deprived of the participating in the bidding tender.
Mr.
He must
Pari.
satisfy that how is
Mr.
it?
Pari, Mr.
Yes.
Pari, we are unable to see that order which you have read. So hurriedly, we are unable to.
May I make after 5 minutes, my lord is coming, then I can join in the court physically. If
Bring that writ petition, earlier writ petition. What is the number?
So number is given.
11,000 to
11,025.
2025.
Bring the file.
11,025.
2 minutes then. Bring that file. Somewhere else. Soft copy.
Whether I should apologize because of me, it was.
No.
16th later, sir.
There is no order.
There is no order. Only one order is there.
But, can I just take 5 minutes?
The order dated 6/5/2025.
No. It was only invitation was whether they are the stakeholders or not.
Yes.
And also apprise the court as to how the petitioners are deprived of participating.
We filed an additional affidavit. Thereafter it has not come and they have cancelled. Tender is cancelled.
So in that event, they can definitely raise that issue because you have cancelled the.
My lord, I'm just
Annexure
clarifying.
9, Lordship, can you see Annexure 9, page 163?
Within 2 minutes, I'm clarifying.
This writ application, Annexure 9, page 163, Lordship, can you see?
The date is important. This is one day
Yes.
after the tender.
Yes.
163.
That was in relation to the earlier one.
No, my lord, this one.
Oh.
23/5/2025.
Have you given a suggestion?
Yes, we have given a suggestion.
Have you given a suggestion?
Yes, Annexure 15.
30th.
But see the stakeholders, mailing list 164. My name is serial number 5. 164. They have called comments from SRT, DRT approval manufacturer, agencies having approved QAP for outstanding quality assurance plan.
You are Khemchand.
Serial number 5.
Yes.
Khemchand. They have other agencies, they have also given 165.
200, page 200 is
At page 200, let me kindly see. 35/2025, I have also given.
Page?
My comment.
Page
Annexure 15, page 200. That is mandatory required before it can be finalized. And before finalization of the procedural order, they have
So you have given. Have they not?
No, they have not considered.
Yes, sir.
My lord, I'm just clarifying. This is a tender which relates to the the railway line track, it will be joined, and the testing is that the particular machine which has been procured by the railway for the purpose of the automated testing system. What is that? The particular now this the procedure which is adopted by the railway earlier occasion has been increased, and they are coming with a new technology. The new technology is such the particular persons who have claimed before my lord and they are in the list, they are previously doing that work. Now question is coming because the Vande Bharat other speed trainers coming, the new technology will introduced and new criteria also included by the railway, and that basis the tender was floated. Earlier occasion they have raised some things which was
now the question is that before you floated the tender,
yes,
you have invited any suggestions or comments from them?
Everybody suggested. Accordingly, one clause 6 has been added, my lord. After that, 3 persons have participated, out of which 1 person has been deprived, them to fulfill the criteria. And out of 2, 1 has been awarded, and accordingly, he has been given this
letter of
acceptance. Letter of acceptance has been issued only in the stage of executing the agreement. And this process has already been completed. And prayer is such, let's see, come to the prayer. The first prayer A is already in focus because already it was finalized. As regard
no, first is the cancel.
My lord?
Cancellation of the tender.
Yes, that is there. First tender was cancelled and
no, this new one.
New one.
Yes.
Let's see, paragraph A. Issue a appropriate writ or order direction directing the opposite parties to immediately cancel the interim tender, the present tender.
Present tender.
Yes.
What he says, he has prayed for that.
Yes. That tender cannot be completed because letter of acceptance is issued because 3 persons in participated, out of which
according to you, if the letter of acceptance is issued,
yes,
then the court's power to cancel the tender is completely taken away.
No, I am not arguing, sir. What I am submitting, my lord, because their prayer is such, the tender should be declared null and void because the illegality is there.
Correct.
We don't have an illegality, rather we have
added. What we wanted to first.
Right. That's why I am praying, my lord. Let's take it after vacation.
What?
Then immediately I will file all details clarifying the position. Railway is adopting all transparency as regard to technology is concerned. The clause 6 is data pro. That's all process.
Where is the technology you have indicated?
My lord, they have not participated. They don't have a locus standi. What I am saying, my lord, they didn't have.
If by putting a particular stringent eligibility criteria, you are depriving somebody to participate, can they not come forward and say that this is unconsignable, this is unreasonable, this is absolutely irrational? Can they not?
Absolutely, my lord. Absolutely. I am considering the same, but it is not. In this case, those have doing the same work now after coming new technology, they have given.
Show us from the tender that some new.
Yes, that's why I am praying, my lord. Let's me keep it to after reopening that. I can clarify everything.
Page 37. Page 37.
37.
Yes.
They didn't have a technical skill. That's why they are not able to participate.
I understand.
But see page 61, the other one.
Other one means?
The previous one. Identical. Page 61.
This previous one, we have given a 5 criteria. Now we will add another 6, number 6 criteria, based on which it is
finalized. That number 6 criteria.
So page 61.
It is data. That is data entry. What I don't know actually. I don't have skip. That was added with this criteria.
It is having so kindly turn to page 38.
Let us give to the
38 eligibility criteria.
Yes.
But this eligibility criteria is page 38
of the present tender.
Yes, current tender.
Yes.
Is the same as the previous tender. Page
eligibility conditions.
Yes.
Page 38.
Page 38.
Yes.
Technical eligibility criteria. Well, not special.
Yes.
But same thing if your lordship turns to page 62
of
the previous tender.
So we'll have to go.
No, it's there, my lord. It's there. I filed it.
Page 62.
Yes, page 62. Page 62. I filed it. At page 62, the special technical criteria. Sir, same thing, identical. Well, let's kindly look at page 44 for it.
Yes, it appears to me the same.
Same, Malad.
No, my lord, let's see page 68 onwards. Page 68 onwards, let's see what I peruse because I don't have instruction, but from their record I am saying so. Research Designs and Standards Organization, Lucknow. Then that organization has given this amendment history that is 12/9/2018 onwards. Then Lordship may come to the next page.
Page
69.
69.
Page 69.
Yes.
That Lordship may come to the.
That is what I am relying upon. This is the apex document.
No, that is the old one, man. It is 23. Now, why are saying that about the latest technology is coming on 2025, 24, 25. And it is this document, the date of effect on 15/9/2023. Let's see the above. Annexure 4, that vision 2.2. Let's see the
4.2.
Then date of effect 15/9/2023.
15/9/2023.
My lord. And
you are defining the paragraph 4.2.1.
4.2.
4.2.1.
Yes. Yes, madam.
As per the recommendation of the standing committee duly approved by such and such on deliberating the matters of vigilance, Directorate of file number such and such.
Then how it has to be proceeded? 4.3. Display of provisional draft RDSO standard. 4.3. Yes, it says the concerned director shall ensure that contract detail concerned RDSO official clearly available to all the stakeholders on the RDSO public website for sending their comments and suggestions.
That's why the
Then
last with other your stakeholder not satisfied
creation
us.
of research document and the comments. Then 4.5 display of final draft, copy of RDSO public website. Copy of the final draft standard and research document shall be put on the website at least 15 days. After expiry of the time, these documents may be removed from the website. Creation of finalization of the copy of standard. Standard has been defined here also. And then it will be finalized. But kindly see the date on which date.
Now they are taking.
The date is 27.
No, this is the procedural order.
Procedural order 27/6. But this order has been passed.
Was those suggestions and the comments were placed before the committee members?
Yes.
Whether those were placed before the committee members?
They have not taken a decision.
No, my lord. It was placed with the committee member or the expert team has been taken into consideration.
Oh.
This organization that is in Lucknow, that is Research Design and Standard Organization, is a organization under the railway. They are making a research about the new technology, everything. Then they are taking consideration with the stakeholders. Thereafter, they were taking a administrative decision in this regard. Basing on which the tender was floated. It is not that.
He's on a different point. He says that when the tender document postulates that a draft tender will be uploaded on the website.
Yes.
Inviting any suggestions or comments.
Yes.
And once the suggestion and comments come, then the finalization can only be done after placing those before the committee and by a majority members of the committee if they have to take a decision.
Yes.
He says that I have given a comment and suggestions, but I believe that it has not been placed
Not
before the
been done.
committee. Nothing has come up.
Yes, sir,
And
not
suddenly
possible also.
one fine morning you have finalized this particular the tender. So what he says is that this is contrary to this particular old
Only-
clauses. That is a clause 4.2.1.
4.2.1.
4.2.1.
No,
4.3.
4.3.
4.3 and 4.6.1.
6.1. Sir, only one
These
day
are
gap.
these are the two clauses which are
My lord,
there.
what I'm saying, it is a 2023, what are they are showing. Thereafter again, there is a suggestion was sought for, and there is everything has been taken care of. Accordingly, this.
Sir, I understand, but
My-
the modalities is provided that
Yes.
these documents
Yes, my lord.
means the suggestions or the comments from the
Stakeholders.
stakeholders. They will be received by you
Yes.
and we place before the committee. And the committee, by way of majority, will decide, arrive at the consensus.
My lord, what I'm
What to
saying,
do.
my lord, all
So there
formalities has been
must be a
completed,
meeting.
my lord.
There must be a meeting of the committee.
My lord, this minutes has been prepared or formalities has been completed.
Where is that minute?
But that will I produce. That's why I'm saying, my lord, let's keep it after vacation. I will produce everything.
Sir,
Every
tender,
transparency has been made.
sir,
All things have been made.
tender date is 22/5.
Tender
They
date is-
invited 22/5/2025.
Just 1 minute. Tender date is
Yes.
22/5.
25.
And then
Annexure 9 is 23/5.
Unless until he will not stakeholder there, it cannot be.
Objections invited on 23/5.
No. It is the what document there 15/9/2023.
22/5 was a draft.
Yes.
And then
No. Tender. Tender was done without complying the provisions.
Then when the comment and suggestion was sought,
23/5.
Exactly.
23/5.
Yes, no. That
Sir, date is there.
Yes.
where do I get?
Annexure 9.
Connection. Page
Page
163. 163.
Page 163. Kindly see the date. 23/5.
correct?
163.
Realize that mistake.
They have also mentioned office letter dated 22/5/2025.
So by 1st June,
Yes.
you have invited.
Yes.
Objections.
That was also been done. That's why the clause 6 has been added in the clause.
When this final tender has been floated,
22/5.
22/5, my lord.
there's a final tender.
Yes.
Then why they are inviting?
No.
So that is the
This tender dated
Procedural also on which this is based.
7/2020. 10/7/2000.
to
This-
formulate this procedural order, they have to follow this apex guideline, my
My
lord.
lord, I have
They-
that
they have-
letter of
if you also
acceptance.
look
They have
at
a
page
tender number
44.
such and such, closing date is 10/7/2025.
Sir, rule sir, कहिए sir. Page 44, let's me kindly see. Only 2 dates will, I think, satisfy your lordship.
Yes.
This is page 44. This procedural order first was published on 27/6/2023. Annexure 2. But before it has completed the procedure,
That was in 2023.
yes, 23,
Yes.
no comment were invited. Then when I filed a writ application, I raised objection. They cancelled the tender, invited objection. But before
Invited objection from where?
stakeholders.
From in respect of that tender.
No, sir, not tender. In
Procedural
respect of the procedural order. Unless this procedural order is finalized, tender cannot be floated. Because the procedural order prescribes the modality on which the tender has to be floated.
Page 44.
Sir, kindly have a look at page 54.
We are at petition. Hey, Which you gave is the earlier repetition or the latest one?
Latest.
Huh?
This is it.
You are referring page 44.
Yes.
That was in relation to the earlier tender.
Sir, same. What has happened, let me clarify, my lord. They have to prepare a procedural order on the basis of which a tender has to be floated. Because tender also says I have followed the procedural order. This procedural order was initially made in 2023.
Correct.
But so that has been accepted by Railway Board immediately. This has not followed the basic requirements of the apex document annexure 4. This document says on 4.3 you have to publish in the website, then you have to invite objection.
So they did not. Then what
It has not been followed. So that objection we raised in the previous tender, saying that the tender condition which derives
in this tender, what has happened?
In this tender,
They have not invited any
no,
suggestions.
sir, now they are inviting. They are inviting now in 23.5.
23.5, they are inviting a comment
Right.
and suggestions.
And
so give your comment and suggestions.
We have already given.
Yeah.
Before finalization the same, they have floated the tender.
Oh, that is what I am asking you, sir. We are not concerned. What you are saying is that in an earlier tender,
yes,
they invited, you gave an objection, procedure and all, everything, technical eligibility criteria is to be ascertained.
Correct.
And is to be decided.
Yes.
So you came and challenged that particular action of the authority.
Then
that you have not followed the apex document.
Then they cancelled the tender.
Then while the matter was pending,
yes,
then they cancelled this tender.
Cancelled the
That
tender.
means it goes.
Yes.
So this objection also goes.
Correct.
Everything goes.
Everything goes.
Now, according to you, this apex document, which is there,
Which has
is
not been
binding,
followed, which has
also
not-
postulates the draft one has to
Yes.
be uploaded. So according to you, the draft one
Now uploaded.
now uploaded.
Right.
So if it is now uploaded,
Yes.
then how can you issue a letter of acceptance without the finalizing the tender?
So therefore, that I say, without finalizing that, tender cannot be floated.
True.
Now they have floated a tender.
Where they have floated?
Annexure 1. Annexure 1.
What is the date?
Yes, kindly see the date. 22/5.
Where is the page?
Page 37.
Second column.
Page 37, second column. 22/5.
23/6, 2025.
20, yes, ma'am.
That is
Before-
closing.
no,
Closing.
no, closing date is 26.
Uploading.
Closing date.
Uploading date is 22/5/2025.
Reading system.
Top.
Where is that, sir?
No, that at the bottom when you are talking about, that's a downloading.
No,
that is
table.
the- Table and annexure 1, the table, first column. Mara.
Right.
Yes.
Right.
Reading system, then date, time, uploading tender.
22/5.
Yes.
Yes.
For 23/5, they have invited objection.
Yes. Have you given?
Yes.
Yes.
When?
Sir,
35.
When?
Sir, annexure 15.
35.
Page
Page
1,
200. Page
Page 200. 35/2025.
Yes. So before 3rd June.
Before finalization.
Before 1st June.
Yes.
So 3rd June they are supposed to meet.
Yes.
Have they?
No. Because prior to that, before finalization of the same, they have
float
floated
this.
tender.
No. Because it says it may be a draft one. Sir,
Tender.
there are two
Tender-
modalities.
tender-
4.1
Sir, annexure,
4.2 says that they have to float the draft one.
sir, draft 1 is this one. Annexure 2. madam.
No, annexure 1.
Yes. This
a
is
draft
annexure 1.
They
Annexure
say
2.
4.3, the clause says that provisional draft standard shall be displayed
That is annexure 2.
for at least 30 days on a RSDO, RDSO public website as per the relevant norms. And the norms and a comment shall be invited from all the stakeholders.
Correct.
The concerned directorate shall ensure that the contact details and such and such shall be done.
Yes.
And then you say that 4.6.1,
Yes.
6.1, that says that a final draft copy of the standard
Published.
shall now be prepared, including the suggestions, if any, from stakeholders.
Absolutely.
The draft The final draft standard with documents containing the comments received from shall be put to a committee member for majority consensus. Member secretary shall hold a meeting, and for inviting, based upon the outcome of the meeting, minutes will be drawn. Based on the accepted changes and prepared reasoned document to be kept in the record, final standard shall be prepared and issued with the approval of ED, controlling the items. When final decision is taken, such and such, the standards shall now be published for use by BIS or railways and its vendors, giving its unique identification number as such and such, ABC short form and such and such.
So now kindly look at Annexure 44, Annexure 2, page 44. This is the draft.
Yes. So they invited.
No, sir. Draft is procedural order. Annexure 2, page 44 is the procedure, but they have treated this as final.
That is 23.
No, that's the thing. That was challenged. The same procedure.
Yes, 44 is
Probably we are not convinced. To be very frank,
Sir,
there appears to be a factual dispute.
No, sir. 1 second, I'll.
Sir, very, with all deepest humility and the respect to my command. These are the letter at page 44 pertains to an earlier tender.
No, sir. Not a tender, not tender. This concerns the
subject is a procedural and technical eligibility criteria that was of 2023. No difficulty. This does not come within the purview of 4.3.
Correct.
4.3 says that they have to publish a draft and then invite an objection from our suggestions that what to do. 4.6.1 says that after receiving the suggestion, it has to be placed before the committee. Committee will take a call. And thereafter, they will finalize the standard final one.
This has to be finalized.
This is the final one. Once it is a final one, it does not invite any further suggestions to come.
So this is not actually the final one because this has not followed the procedure.
This was challenged.
That is the dispute.
And they have floated this, they may be a final one in the month of June, whatever. 37, they have floated it. It was absolutely unwarranted to invite any suggestions. Not warranted. Not warranted.
Sir, actually, this is a procedural technical eligibility criteria on the basis of which the tenders are floated. Am I clear, Malad?
But no, not clear. Because I am grappling with page 44 and page 163.
Yes. 163.
163
invites objection.
Is the invitation for procedural order after the tender is floated on 22nd of May. This is a letter dated 23rd May.
Correct.
Suggestions by 1st June.
Sir.
Which is in tune with 4.3.
Right.
Again. That's why I say. So forget what has happened in 23.
Yes.
Now they invited the fresh one.
Right.
Now you have given on before 1st June.
Yes.
This letter says that these received suggestions will be placed for deliberation on 3rd June.
3rd June.
Now on 3rd June, if it is placed, and then if the committee has decided either to accept the suggestion or
modify it
or not to accept the suggestion.
Not to accept it.
If they accept the suggestion, they can accept in a limited sense. No difficulty. They may modify it. They may not modify it.
It has not been done, number one.
So this is what I am asking you. The question is that whether they have followed 4.6.1 in that sense.
Not at all.
You are taking me to 44.
I'm sorry. No, 44, why I'm saying, this was a draft one.
That was the earlier one which is quashed and cancelled.
No, not the earlier. This is the only one.
It is not quashed. 44 is not quashed.
44 has not been
then why 163 is coming?
Sir, 163 is coming Because when we raised
in relation to page 37,
yes,
22nd of
May, 22nd
no,
May.
this is 22nd of May.
Yes.
Yes. So this is a fresh one which does not see the light of the day in 23. Does it see a light of the day in 23? No, because it is dated 22nd of May 2025.
I'll just 1 minute. 1 minute, madam. But the apex body says this is the guideline on which the procedural order has to be prepared. The procedural order in 23 that was prepared was not following the procedure itself as per the apex document, 4.3 and onwards. So therefore, when they floated a tender on the basis of that, we raised objection to the REIT application. REIT application, they have accepted the contention, but it has not been disposed of. They cancelled the tender because they following this, they have floated the tender. Therefore, they say it has not been in accordance with law. Now they have invited objection in this draft. Now, once the objection is invited, they should take a final decision of the final draft, final procedural order. Before finalization of the procedural order, now they have floated another tender. They cannot do it. This procedural order cannot be the guiding factor.
Correct. 163. See the letter of 24. See.
On 3rd June, there was a meeting. Mr. Pari, 3rd June.
As far as that instruction I didn't have, but basically see the annexure 15 what they have submitted before the authority concerned, that annexure
No, it
15.
boils down to one.
Why not?
That he has submitted some suggestions.
Yes.
Which would alter. Whether those suggestions were placed before the in the meetings held on 3rd June 2025 pursuant to Annexure 9.
Annexure 9, page 163.
Yes. Annexure.
That last revised
now,
comment.
now the question is this.
Yes.
Annexure 9.
Yes.
Before 1st June, you have to furnish objections or suggestions.
Yes.
Admittedly, he has furnished
on 335. Yes.
We are admitted.
Yes. Annexure 15. Yes. Yes. Yes.
So whether that document was in the placed in the meeting 3rd June 2025.
Yes, my lord. Yes. What if they have basic?
What Mr. Ishwar Mahanti,
yes,
with his nodding face, he says that on 3rd June there was no meeting.
No, my lord. Whatever that has been fixed and criteria has been fixed, and whatever document suggestion by any stakeholder.
There was no meeting on 3rd June. What do you say?
We have not been called after that.
You are not.
You are not supposed to be called, sir. You are not supposed. Under the
That's it.
no, what I am
22nd May.
There appears to be a lot of confusion. I tell you very frankly, unless I express my mind, I do not think that I will be able to justify my duty. There are two things, Mr. Mishra. Please tell me, and both of you, please tell me. There are two documents which is forthcoming. One is Annexure 1 at page 37. If you come to that.
Yes.
Where the date of the uploading of the tender is shown as 22/5/2025. Correct? Yes. Come to page 61, which is Annexure 3.
Yes, madam.
I find it's the same document practically, but the date of uploading of the tender is shown as 13/2/2025, means 3 months prior thereto. No doubt. This is what I find, that these are the two tenders. Now, you are relying on a particular document at page, say, 71. Let us see.
71. 71.
Correct?
71.
4.2. We say
4.3.
that the creation of a draft RDSO standard. What is this?
This is Annexure 2.
Annexure 2, my lord.
Page 71 of your writ petition.
Annexure 2 is page 54.
I do not know Annexure 2. I am talking about Annexure 3,
Annexure 3.
which starts from page 61. And
Sir, this is research, design, and standard organization.
The concerned officer at the level of the member of the secretary shall put up the proposal for new standard to ED controlling for approval to initiate the creation.
Yes.
For creating initial draft standard, the design development process is to be followed. When putting up the file to the ED controlling item, such as the member secretary shall prepare the self-contained note addressing the following.
Right.
Then these are the existing. Then come to 4.3. It says the provisional draft standard.
Yes.
What is this? RSDO standard.
Yes. RDSO standard means research design and standard
It will be
organization.
displayed for nearly 30 days on their particular portal, inviting a comment or suggestions from every stakeholder. And therefore, once that is there, it is called a provisional draft.
Provisional.
What is that? Creation of a RSDO standard.
Standard.
Then the 4.6.1 says that finalized copy of the standard is to be done.
Correct.
How it is to be done? That there is a
Procedure.
committee, it is to be put in the committee will take into consideration, everything will be done. And then once the finalization has taken place, it will take place for at least in the record for 10 years.
Right.
This is what I find so far as the RSDO standards are
Guideline
concerned. Now I find that after this 22nd of May 2025, this particular tender which they floated, they issued you a letter on 23rd May 2025. In this letter, very interestingly, they invited your comment and suggestion on the procedure and the standard.
Right.
Which is at page
163.
Standard is at page 44.
Standard is at page 44.
Which is at page 163, which they say that, the procedure
that is what
meeting for discussion on the procedure order.
Yes.
And revised technical eligibility criteria of such and such.
And the procedure order is at page 44. For which the objection has been invited. Annexure 1 and 2 attached to this letter.
Then he talks about the office letter dated 22nd May 2025.
Sir.
At page 163.
Sir.
It says that in continuance of this office letter referred above. Where is that letter of 22nd May 2025?
Sir, annexed to this document at page 47.
That letter.
That we don't. That
No.
letter we don't.
22nd May.
22/5/25.
That letter we
22/5.
So that letter we do not have. That letter we do not.
He says that interested firms in USFD testing of the rail using a phased array such as
Office letter 25 we
through outsourcing are also requested to provide valuable comments.
Yes.
On procedure order and revised technical eligibility criteria for testing of the rails.
Yes.
Which are available in a public domain through email by 1st June.
We have filed it.
and then say that the meeting will be held on 3rd June. Now, on a 3rd June, it appears that you have submitted at page 200 on 30th of May. Now, the question is that whether they have placed it on 3rd June.
Correct.
Now, what it has got any relation to a tender which has already been floated
Right.
on 22nd
My
May.
limited submission before Lordship is on 22nd the tender has been floated. Tender has been floated on the basis of a procedural order. That is Annexure 4 and Annexure 2. That has not been finalized. If the procedural order has not been finalized, following the procedure, no tender could be floated. The tender document says we followed the procedural order. So, in the absence of a final procedural order, they could not have floated. They have disposed this after 3rd June only they can do it.
Let's see the same letter I am referring to is 163. My lord is asking this 3rd May, 3rd June. That letter, the meeting of discussion for procedure order and revised technical eligibility criteria of the phase every single trial test such and such for the testing trial. Reference this office letter, even number dated 22/5/2025. It is not that the new result letter is given. It is referring to that letter, basing on which that is given on 1st May 2025, and last meeting was called for 3rd May 2025.
3rd June.
3rd June 2025. Sorry, minor. The 1st June 2025, then 3rd June 2025.
They gave an objection on
Yes, they have given on 30th May. That is taken care of, and everything has been.
Where is the 3rd June resolution?
That instruction I have produced. Everything was last occasion.
If that is not there, then in that event you can't proceed with the tender.
My lord, here is the case. What happened? He is not fulfilling the basic criteria.
This is why he raises that the conditions you have heard. That's why it says that the revised technical eligibility criteria.
Let's see for a moment, page 200, Annexure 15.
Yes.
It is their prayer.
Yes.
Initially, I am just reading, my lord.
Initially, that's the final prayer.
No, my lord. They have prayed before the authority concerned. On 35/2025, Annexure 15.
Correct.
They have written to the director VA tracking destination Lucknow. This is the expert body.
Correct.
And they have written the second one, reference to the above paragraph's comments for procedural order and technical eligibility such and such. Next paragraph for phase arrest alternative or test PAT is under. The eligibility criteria should be revised to allow my outsourcing agency that can be successfully demonstrate its capacity to perform phased array testing to participate in the Indian Railway. Right. That means he was asked, he is not able to fulfill technical criteria and they are not eligible to participate in the testing.
Sir, we understood.
Yes.
Then what for this comment and suggestions were invited? He says these are the two things for which the comment and suggestion was invited. One was the procedure order, another was revised technical eligibility criteria.
Yes.
He says that this eligibility criteria which you are putting up is not correct. You have to revise it. And then he says we request at the bottom of 30th June.
Yes.
We request eligibility criteria to be changed to. Then he says 50 lakhs for outsourcing, says energy required this much, blah, blah, blah. They have said that this is a comment.
Yes.
Now, if that comment is required or suggestion is required to be considered and weighted either in affirmative or negative by a committee, then the committee must pass a resolution. And after the resolution is passed, the committee may proceed to float the tender, saying, I am not accepting any kind of a suggestion. But you have already floated a tender, yet you invited the suggestions in the midst of a tender. Kindly visualize.
Well, again, once again, I am clarifying. The previous tender was floated, he has challenged. He is saying the same thing, that I am not fulfilling the eligibility criteria. I am not allowed to participate because I am not fulfilling the minimum criteria what we have fixed. The second time we have come with a concrete proposal maintaining transparency as well as given chance to any of the stakeholder. If you have any
why you issued a letter dated 23/5/2025? There was no occasion to issue the letter dated 23/5. You could have simply just proceeded on the basis of this 22nd May. Finish.
Because
I have taken into consideration all such objections and suggestions. We have not. We are proceeding. Why you invited after the floating the tender?
It is a different type of tender because the testing agency those it is not a general tender, my lord. Suppose anybody put the L1 L2 like this.
I understand, sir. If you are of the view, why you issued a letter of 23/5? Why? Why you invited the comment and suggestions? Your authority, you are an authority, you have already taken.
Yes.
This is a very specialized, is a very specialized work, and this must be the eligibility criteria. There cannot be any other eligibility criteria.
That is this.
Why you issued 23/5?
Because more transparency. Yes.
Why?
More transparency, my lord, because
this is the transparency. Then you'll have to show the reasonableness. You have to show the reasonableness that you have taken into consideration.
Definitely.
And
yes.
If after taking into consideration you cannot proceed on the basis of 22/5, you should have issued a further tender.
My lord, here is the case.
Rejecting there.
Here is the case. Neither he was eligible for previous tender nor the present tender. Nor he is
both the cases, he says that unless you revise the technical eligibility criteria, I will not come.
My lord, because according to their schedule, you cannot fix the condition.
Reject, sir. Will you not take a decision? I am asking, why you invited the suggestion?
After 22nd 5,
yes,
you have invited this
suggestion.
My lord, 22nd 5 we are doing the tender.
Meeting for discussion.
Yes.
You say meeting for discussion on procedure order and revised technical eligibility criteria. If you have said that we will meet to discuss, and then you said, give me a suggestions, then will you not take into consideration those suggestions?
My lord,
why you invited?
My lord, here what in this case I am not present. First time list I don't have any instruction.
Sorry.
But previous date there is a case was listed. Ask that officials. They have told me categorically. This is a tender where we asking the stakeholders if anybody is a technically qualified, then come and test before us. We want more bidders. They can easy more transparency can be made and more person can be enumerated if they are technically qualified in this manner.
So you could have said that we are giving all the stakeholders who meets the eligibility criteria may give apply. It's an open tender, no difficulty. I wanted a more participation. Why you invited a comment and suggestion? And that too,
language-wise,
for revised technical eligibility criteria. What is the meaning of the word revised?
Revised. There is what happened in earlier tender. There is a 5 condition. In present tender, they are coming a 6 number of.
You put 100 number of.
But we should not ask for.
We don't mind, but you follow the rule.
Yes, we have maintained all. Let's make keep it to after vacation.
No, sir.
After vacation, I will produce all the records, my lord. I will produce all the records.
No, you produce the record, but it does not mean that you have to produce third June meeting.
Definitely, we can produce, my lord. But here is the case.
What we propose, as it appears, the LOA has already been issued. What we propose is that we wanted to look at their stand on 3rd of June. So we are permitting you to move before the vacation, giving you liberty. Let them produce on that day, the 3rd June meeting, the minutes. If it is not, the court will pass it.
Let's see for a moment. Let's see page 172. That based on the feedback received from the zonal railways, this procedure order will be modified in consultation with the M&C Directorate RDSO, the safety. All persons employed in the alternative such and such are responsible for using. That means the railway is open to all the stakeholders, those are facing the technical qualification. They can come forward and give the testing, my lord. I'm admitting one thing, my lord. Lordship is correct in one sense that in the because they are engineers, they might have using some words which
No.
Yes, my lord.
They're all 24.
24.
Despite although the tender
Affidavit in item 1 and 2, both the cases we have filed the so-called affidavit, SLP pending. In one of the case, that is item number 2, SLP was listed before the Honorable Apex Court today, and the Honorable Court has passed an interim order of stay.
Okay.
So that
So
I
let's,
also
adjourn on the
Maybe
on the prayer of the LS contemner.
The Lordship directed to file the affidavit to the opposite party,
Oh.
my lord. And they have to comply the order that they are page 14, my lord.
Yes,
Next
item
one,
number
my
3, my lord, orders complied. I'm serving copy on my learned friend. The orders are
You
complied.
just go through it. We are keeping this after vacation. You come.
My
If it is fully complied, no difficulty.
lord.
We'll dispose of the matter.
Yes. This is a matter, my lord. 100 families have been.
Yes, sir. If he has
Land
complied
out-
the order, then you should be very happy.
No, your lordship.
Yes.
Both
It
the
is
cases
submitted
that-
by Mr. Das.
Item number
Talk
4.
with my brother.
4 also
Just
same.
keep it.
4 same.
Yes, same.
Item number 5.
Item number 5 was just file a complaint affidavit as the flag B. I'll have to see flag B.
Have you seen that?
item number
Have
5
you
and
seen
6.
that flag B?
No, my lord.
Now the direction to repetition.
There is a compliance affidavit. What do you say? If it is already complied with, then would you continue with the contempt?
I have not gone through the.
Why you have not gone through on the prayer of the petitioner after vacation?
Right.
Go through.
Item number 6.
The item number 6 is similar to item number 5 below. In this case, the representation has not been disposed of because some time is required.
Is on the prayer of the counsel appearing for the LS contemner.
7.
Your Lordship, item number 7. On the last date, direction was given to the state to file affidavit.
What?
Affidavit file.
We have filed an affidavit, my lord. Ashoka's affidavit, we have filed the hard copy. It was already e-filed. Lord, in this case, we filed an SLP.
And what is the outcome of the SLP?
Filed on 18th. My lord, 18th of this month. It has not been listed. However, my lord,
With section 5?
SLP is filed, my lord.
With section 5? Obviously.
Section 5 of the Limitation Act.
My lord, this, my lord, item 7 is similar to item 8. In item 8, my lord, the SLP has been listed and a stay has been done. But in this item 7 has not been listed. Yes.
It will receive the same. That's all.
Millard. Did the Supreme Court today fix the whole matter, November 11th November?